I got a question on one of my other threads that I thought it was important enough to answer here in a separate video. And the question is this: what if you filed your employment law case with the EEOC, or the Equal Employment Opportunity Commission? What happens if you do that and then the EEOC then refers it to a local office? The question I got was somebody in Maryland had their case at the EEOC, and the case was then referred to the Maryland Office of Civil Rights. So here's the deal. There are a lot of states and counties that have what's called work-share agreements with the EEOC, where they are essentially like an arm of the EEOC. And what that means is that you can go and, let's say if you're in DC, the DC Office of Human Rights, you can go to the DC Office of Human Rights, file your claim there, and check a box that says, I want to cross-file it with the EEOC, and it will be considered filed at both agencies. Now, there are a bunch of reasons you might want to do that. I think it's worth always doing. There could be local laws that you want to proceed under as well as Title VII. So you want the DC Office of Human Rights and the EEOC to be filed in those places, although only one office generally will work it up. And what happens when it goes the other way? You file it at the EEOC, they send it to your local office. And they don't have to ask your permission, they can just do it, which is what happened in this case. That's generally a good thing. First of all, it's not going to weaken your case. It doesn't mean that your case is in some kind of jeopardy. In fact, it's probably on balance a good sign. The EEOC usually moves pretty quickly to dismiss cases that rightly or wrongly it deems are weak. So the fact that your case is getting sent to a local office is generally a good sign. The second thing is, a lot of these local offices on balance will do a more thorough investigation than the EEOC, which is a low bar. The EEOC, when they say they investigate a case, they're good people there. Their heart's in the right place, but they are very, very busy, underpaid, overworked. So when they do, I put in air quotes, an investigation of your employer, it's usually just sending some questions to your employer for the employer to respond to. It's not like they send somebody to your employer and go through documents and all that. That also generally doesn't happen in these local offices either, but you are more likely to get somebody who has a little more time, a little more bandwidth, perhaps motivation to look into your employer. So you may get a better shake there. It's also, depending on the office, they may have different mediation requirements. For example, in the DC Office of Human Rights, mediation is mandatory, as opposed to if you file with the EEOC, mediation is not mandatory. And generally for employees, mediation is a good thing. It's a chance for you to sit down at the table with your employer or its representatives, and if a case is going to get settled, it's much more likely to happen when everybody's at the table like that. So it's usually better if you're in a local office that requires some kind of mediation. And again, I think on balance, you're more likely to get a mediator at the local office who is really motivated to settle your case. It's a good thing when your case gets referred to a local office with a work-share agreement with the EEOC. Folks have any other questions, drop down below and I'll be happy to try to answer it.